said the government was supposed to comply with my orders. What orders? The orders the Supreme Court just vacated? We're in trouble for not complying with your illegal order that you had no power to enforce at all, which is why we appealed it. You want us to order an invasion of a foreign country? You want us to be ordered to directly negotiate a diplomatic deal? It's not in your power there, Jeb.
They were setting fires, burning American flags, defacing public property. And when President Trump saw that, and the LAPD took more than 2 hours to respond to bring in backup, we knew we needed more law enforcement.
Judge Boasberg, an Obama appointee, having a bad day today after this came across the line from the United States Court of Appeals, or the District of Columbia, his bosses. Remember, this case is the JGG case. Judge allowed them to proceed pseudo-anonymously, so we don't know who they actually are, and ordered Trump to bring them back to the country, turn those airplanes around and blah, blah, blah. Trump said no. This went up to the Supreme Court. The judge said, you can't actually make him do this. This is a habeas claim. You have no jurisdiction over this case at all, Judge Boasberg, this fellow right here. And he said, well, I'm just going to hold on to the case anyways, because I'm going to exercise my contempt powers. Then he got backhanded on that and said, actually can't do that either. So then he said, what I'm going to do is call this a due process violation and try to make writ of habeas corpus claim shoved in there for illegal aliens in foreign custody to get the benefits of the American Constitution. Constitution is not for illegal aliens. The Constitution is not for foreigners. It says we the people. It's for America and American citizens, not for foreigners. So what Trump and the DOJ submitted was this. They said, all right, listen, DC Circuit Court of Appeals, Judge Boasberg's acting like a big Boasberg again. We need you to do something about this. So we're asking for a stay, all right? He's asking for us to facilitate access to deported illegals, and we can't do that, and we're not going to do that. So they write the following to the Court of Appeals. All right, judges, for the third time in just 3 months, the district court, Judge Boasberg, has issued an unprecedented, baseless, and constitutionally offensive injunction that interferes with Trump's removal of dangerous criminal aliens from the United States. Now, the court's first 2 injunctions were blocked on appeal. He's already lost twice. He just keeps going. The third try is not the charm. If anything, it's new sua sponte theory, which means the judge just made it up on his own, that a class of removed aliens may sue outside of habeas, right? We've always said they have a problem. They can file in habeas in the district where they're being held to challenge their removal. They didn't want to do that, though. They went and forum shopped in DC with Judge Boasberg. Then they went over to Maryland with Judge Zenas. And then they went over to Massachusetts with Murphy. And they're just shopping for these people. And they're getting everything they want. Now, to secure a due process right, they say, wait a minute, you're going to certify an entire class of illegals in CCOT, tell us they can sue outside of habeas when the Supreme Court said you literally cannot do that. It's a core habeas claim. He says they can secure a due process right, so they can sue to secure a due process right so that they then can seek habeas. Now that's all despite a conceded absence of any custody. And it's the least defensible one of all 3 attempts. This judge just keeps swinging and whiffing. You're like, just put the bat down, man. You're embarrassing yourself. This court should grant a stay pending appeal, and they did. Now, in March, the district court issued 2 injunctions prohibiting the government from invoking the AEA, Boasberg again, we've been fighting this for months now, to remove the United States from the United States, a group of aliens associated with Tren de Aragua, saying these people need to go. Trump said that they were intertwined with the Maduro regime in Venezuela, but the Supreme Court vacated those orders, remember, it went all the way up, and the Supreme Court also kind of minced on this and just, well, just send it back down. And Judge Boasberg, you know, this is basically a habeas claim. They're calling it a bunch of other things, but it's habeas, and so their claim is in habeas, and you basically don't have jurisdiction. So he kind of took that and then said, well, before that came down, they didn't do something I asked them to do, and so now I can hold them in contempt, and under contempt powers, maybe I don't have jurisdiction over the habeas claim, but now since I kind of had jurisdiction, even though it was illegal, over this case, and they didn't do what I said, now I'm going to hold them in contempt and use all those powers. Then he got smacked down on that one too, and now we're back. The Supreme Court, and it's like, what is Congress going to do? Are you guys just going to let this happen? Are you guys just going to sit around? Maybe you should impeach him or start a proceeding on this, because this is now 3 strikes, man. But the Supreme Court vacated those orders because aliens' challenges to their removal had to be brought in habeas, and DC was not the proper venue for habeas. They were shopping for a forum there. Now, rather than relinquish jurisdiction, Baby Boasberg said, the district court judge pressed ahead with criminal contempt, said the government was supposed to comply with my orders. What orders? The orders the Supreme Court just vacated? We're in trouble for not complying with your illegal order that you had no power to enforce at all, which is why we appealed it. He said, yeah, you should have done it. Literally, that was his argument. It doesn't matter. You still have to follow the orders, even if I'm reversed on appeal. When I'm not, until I'm reversed, you had to do the thing, and you didn't do the thing. Now, the district court, Boasberg, volunteered, however, that the government could purge its contempt. Says, well, we're going down this line, but you can save yourselves. If you want to avoid sanctions, all you have to do is get custody over the people you deported. What? Wait a minute. So that means you're like ordering us to comply. No, I'm not. I'm just saying if you want to purge your contempt, then you can just comply. Okay. The Supreme Court literally said you can't do that. Well, I'm doing it. So they were then imprisoned in El Salvador. He said, you got to bring them back so that they could have habeas relief. Now, as Trump's DOJ already noted and explained in an emergency appeal to this court before, that order violates Article 2. That threatens to usurp the president's power unless the president agrees to give up that foreign power. This court issued an administrative stay of that injunction, and that remains in place. Now, the district court has developed a third way to reach that same remedy. The district court acknowledged, after receiving diplomatic materials, that the United States does not have custody over these gangbangers sent to El Salvador. We don't have any physical control over them or constructive custody, meaning we don't even operate the levers in El Salvador who are in control. We don't have any ability to control these people at all. We have no custody, zero. Now, that finding foreclosed their argument for relief here. But the court, Boasberg, then circumvented that barrier, and he said, oh, okay, well, if I can't do it there, then I'm just going to find there's a due process violation. And as a result of that, he says, well, you can now facilitate habeas review, and then you can cure your contempt. But they say, all right, nice little scam there, Jeb. The district court's third try is too clever by half, writes Trump's DOJ. The court's lack of habeas jurisdiction cannot be cured by reconceptualizing this lawsuit as an implied constitutional cause of action to provide the class of illegals with a right to habeas. He says, well, I don't have habeas, but we're going to just say the Constitution allows them to sue to get habeas. Now, the plaintiff's due process claims necessarily imply the invalidity of their removal to El Salvador, and Boasberg and the court, therefore, lack jurisdiction over those claims for the same reasons the Supreme Court identified in the first round of litigation, which is they are core habeas claims. Now, moreover, even if a freestanding equitable cause of action existed here, like there was a harm that is outside of this constitutional claim that maybe could analyze under the injunctive rules, what, public benefit and imminent harm and irreparable injury and all the factors, they say even if that was true, this court's remedy is incoherent. Boasberg, yeah, and it's impermissible. The district court ordered Trump, Boasberg, to facilitate the alien's ability to seek habeas relief. But the court had already agreed. There is no habeas jurisdiction because a foreign sovereign has custody. So the only way to, quote, facilitate habeas review would be for Trump and the executive branch to somehow seize custody of the entire class of aliens from El Salvador. You want us to go in there by force or through coerced diplomacy at the hands of Jeb? A federal court obviously could not order the government to do either of those. Court of Appeals. The court order from Jeb is therefore untenable because in the absence of custody or control, the alleged past deprivation of their ability to seek habeas is no longer redressable in this court. So put simply, Court of Appeals, the fact that the United States lacks custody or control over the gangbangers in CCOT does not just deprive Boasberg of jurisdiction, even he knows that, even he admitted it. That fact also forecloses the alien's ability to pursue any other equitable due process claims as a backdoor route to a non-existent habeas remedy. We're not going to allow foreign aliens some sort of constitutional exception to file foreign claims, utilizing foreign claims of being admissible to the United States, utilizing our Constitution to do it. It's our Constitution. It is for us. It is not for the entire world. For everyone saying that all of these illegals get to come into our country and then demand that they get the same access and privileges as citizens devalues your and my citizenship. And we are tired of that. It is a sacred right and privilege, right, that we have here. And the idea that it's just watered down because everybody else deserves a piece of it is ridiculous, and it's not going to be happening anymore. So the Constitution does not provide some escape hatch and backdoor route. The district courts and Boasberg's increasingly fantastical injunctions, making this stuff up, continues to threaten serious harm to the government's national security and foreign affairs interests. This court should grant a stay pending appeal, and they did. But here's more. On March 15th, Trump issued a proclamation invoking the AEA. TDA got designated a foreign terrorist organization, and it said a bunch of things. On March 15th, 5 Venezuelan nationals who were detained in Texas sued in DC, remember? And they all got ACLU and lib gangbang lawyers all coming in, working pro bono, saying stop them, we need a class action essentially, making them putative class members, and then issuing nationwide injunctions to block the government from removing anybody. Although they initially sought relief under both the APA, which they never should be allowed to do that, and by a writ of habeas corpus, they later dismissed the habeas claims. Do you know why? Because Boasberg told them to do so. He said, if you keep that claim in here, I'm going to have to dismiss your entire lawsuit because I don't have have jurisdiction over that claim. So wink, wink, nudge, nudge, drop that. They did. Now, the court granted then an injunction, said, well, under the APA, created a class of gang members, all non-citizens who are subject to the AEA, and dropped that. We covered it here. The government appealed both those injunctions, filed an emergency motion for a stay. This Court of Appeals issued a divided ruling denying the stay. Each judge wrote separately. The Supreme Court, all the way up there, then vacated the orders for lack of jurisdiction. Says, sorry, Judge Boasberg, you lose. That was a while ago. Finding that their claims fell, wrote this, within the core of the writ of habeas corpus. They're suing about their detention. That is a habeas claim. So it must be brought in habeas. Quoting, the Supreme Court sent it back down to this maniac judge who is ignoring it multiple times, now on third time for a stay, and Congress is just sitting there like... Now, for core habeas petitions, they say jurisdiction, Supreme Court, lies only in one district, which is the District of Confinement. That is in Texas. That was not in Colombia. Now, by the time the district court issued its second injunction back on March 15th, some members of the original class had already been removed from the United States. They later arrived in El Salvador and were detained under El Salvador's own authority. Okay, you're holding these other people. They're not U.S. citizens. They're gone. Thanks for taking them. They're out of our country, and goodbye. Now, that led to further rounds of litigation. So the gangbang lawyers went crazy. On April 16th, the court issued a final order, said, you know what, Trump, you didn't turn those planes around. Therefore, I'm going to hold you in criminal contempt for having failed to return the aliens who were removed before the order was issued. Remember, like we went through the timeline on this. It's turn the plane around. It's in the air. Where was it? Did it stop in another country? What time did it take off? What time did it land? What was their aeronautical speed? It was ridiculous. The court offered that the government could purge that contempt by asserting custody, just bring them back. Otherwise, the court threatened Trump, said it would seek prosecution. They were going to appoint a private prosecutor if necessary to go investigate Trump empowered by the courts. Maniac. The government immediately sought relief, DOJ writing here, saying, explaining that the order required the president to do one of two things, either give up his foreign affairs powers by asserting custody over aliens held by a foreign sovereign, which means Judge Boasberg is in charge, or his prosecutorial powers by charging his own officials with contempt because some judge made him do it. Now, this court granted a stay, and that stay is in place, so Boasberg got backhanded again. So then separately, Boasberg invited the gangbangers back to amend their complaint, right? This is how rigged it is. It's like, okay, well, actually, we're just going to knock that claim out and actually come back and add this claim in later. This is a federal judge who's hailed as a hero to address factual developments since March. A new set of plaintiffs, most of whom were already confined in El Salvador, then all joined in the case. They piled in there like a clown car, like they're crossing the border. They sought a writ of habeas corpus and moved to certify a class. It was all non-citizens in CCOT. It's like they get free lawyers, full class action, all the terrorists. You're all just part of this, like on TV commercial. Are you an MS-13 gangbanger who's been abused by the Trump administration? Call ACLU gangbangers, 1-800-ACLU gangbangers, and we'll represent you in your litigation for your sovereignty in America. Says here, all of them were invoked. These plaintiffs then moved for an injunction. They asked the government to cease and take all immediate steps to facilitate the release of the prisoners from CCOT and return the CCOT prisoners to the United States. Now, they say one of these class action gangbangers is actually currently in custody in New Jersey. The district court denied his motion for an injunction because apparently he's part of this class. Now, in opposition, the DOJ said, wait a minute, you can't do that, judge. You lack jurisdiction. There is no habeas jurisdiction here. The United States doesn't have constructive custody over any of these people. And the Supreme Court said, now, after a hearing and after the government filed under seal documents demonstrating that the United States lacks constructive custody over these detainees, Boasberg then ordered additional discovery into the case. He said, well, we're going to keep digging until we find something I can hit you with. Following subsequent productions, we gave him more materials. Then Boasberg said, actually, I do not have jurisdiction. Boasberg came out, filing 148, electronic court filing. Says, I actually lack jurisdiction over the detainees' habeas claims because they had not shown that they were in the United States custody, right? So that's the end of the story. But he's going to find a new exception for foreign illegals to give them access to our constitutional due process, so-called provisions that he's going to make up out of nowhere, and then give them and the ability, the claim to move forward. Now, nevertheless, Boasberg said, well, we do have jurisdiction in equity. We're going to use some other principle that doesn't apply over their freestanding claim that their removal to El Salvador violated their due process rights under American law, I guess. So it applies to even foreigners, right? For every single thing. They got plenty of due process, by the way. So the court then unilaterally modified the class and then certified it, and just he's doing doing whatever he wants. He's totally reckless. The district court granted an injunction based on this made-up due process claim that Judge Boasberg just took, ordered the government to facilitate the class to seek habeas relief, right? So they can't seek habeas relief. They missed the boat on that, like literally and figuratively. It's gone. They lost the right to do that. So the judge says, well, they should have a due process right in order to seek habeas. It's not about seeking habeas. They can't do that. He said, I can't do that. But they have a claim and you have to facilitate the process to seek habeas. It's like totally ridiculous. Now, in considering whether this should happen, he says, we're going to win. Trump's DOJ. First of all, we're going to win. The court agreed that we don't have custody. And Boasberg is fundamentally incoherent. You hear that, Jeb? Incoherent. Coming out of your mouth. Writing. The court agreed. You said there was no custody over the plaintiffs, and therefore there's no jurisdiction for their claims in habeas. Yet the court, sua sponte, out of Boasberg's own booty, recognized a freestanding due process claim by which illegals could seek the opportunity to pursue habeas relief. What? That doesn't cure your jurisdictional problem. How do you have jurisdiction over that? Further, the lack of custody means the government cannot facilitate anything. That's the whole point, okay? If you admit we don't have custody, then how can you order us to facilitate anything? At least not without engaging in some military. You want us to send in the SEAL Team 6 over there? So they cannot then seek equitable relief for these things. Now, because there is no custody, they lack jurisdiction. The Supreme Court already told you this once, and you got told again twice, Boas, that the Supreme Court made clear challenges to the proclamation must be brought in habeas where they're being held in the district of confinement. They were in Texas. You guys goofed. You went to shop for Boasberg. You should have just sued there in Texas, but you missed it, and now they're gone. Since plaintiffs are now being held in El Salvador, the district court could only have habeas jurisdiction over this case if the government had custody, either in physicality or constructive. Now, based on the evidence below, the court correctly concluded that we don't have custody. And constructive custody only exists if the imprisoning sovereign is our agent. But that's not what's happening here. We gave all these people to El Salvador. They're under Bukele's power, and that's it, not ours. The United States does not have control over the facility. And based on the record, following jurisdictional discovery, where the judge was prying into the executive branch, Boasberg actually did correctly rule the United States doesn't have custody. And so therefore, I don't have jurisdiction over your habeas claims. But he made up a new claim for them. That should have been the end of this case, writes the DOJ. Indeed, as to the aliens held in El Salvador, this was the only theory that their lawyers even pursued. But the district court, sua sponte, okay, meaning there was no mention of an equitable claim for due process in their filings. They weren't even alleging this because it's so bozo, ridiculous. The judge just made it up. Sua sponte reasoned that it could exercise jurisdiction over a standalone due process claim targeting the government's failure to provide sufficient notice before they were removed. Now, doing so was reversible error, okay, even apart from the merits, Court of Appeals. The Supreme Court has made clear, courts are not advocates. They must evaluate the theories pressed to them. They can't come up with their own. Having rejected already the gangbangers' constructive custody theory, saying we can just leverage El Salvador to do what we want, Boasberg should not have developed an alternative theory on his own. And that theory is plainly wrong also. Like, even if you go, what? Okay, fine, let's analyze it. Even this bizarre theory. This retrospective claim of inadequate notice in purpose and effect is a challenge to the removal. It's just framed a different way. It therefore sounds in habeas, right? They just come in, it's a detention and removal claim, and they just say, no, it's actually a lawsuit about Kristi Noem's decision to issue a memo to remove them. Well, she didn't have the power to issue that decision. You mean the decision that led to their removal that they're fighting over? No, not about that, but we just want to invalidate the whole thing, right? So that it can be much broader than just any one particular illegal. That's how they get the nationwide injunctions. So the Supreme Court said you can't do that, right? If it's a habeas claim, it's not a contract claim. It's not an APA claim. It's a detention claim. And so you have to bring that claim through the individual in habeas because each individual is unique. Now, the district court Boasberg's transparent workaround will not withstand merit scrutiny on appeal. He's going to lose this too. And as the Supreme Court has said in rejecting the district court's first set of orders, saying their claims for relief necessarily imply the invalidity of their confinement and their removal under the AEA. And so what that means is it's a habeas corpus claim, and it's got to be brought in habeas. Now, applying this logic, the Supreme Court vacated Jebb's orders that were in part premised on a due process claim that they did not get adequate notice. Now, then Boasberg concocted a new claim, but it's no different from the first. Since that claim is not brought in habeas because he doesn't have jurisdiction, this order fails just like the first. Boasberg's novel due process claim sounds in habeas for at least two reasons. Due process is a situation that's been vindicated in habeas petitions. That's what it's about. It's show me the body. You don't have lawful basis for keeping me me in custody. So due process claims are core habeas claims. You're just trying to use a different word. Second, the point of the due process claim is to challenge the validity of the removal. That's what habeas is. So you can't just substitute the words. Boasberg's attempt to separate the due process challenge from the challenge to the validity of the removal slices the baloney coming out of his booty far too thin. If the district court Boasberg were right, due process challenges to a criminal defendant's trial would not challenge the validity of the conviction, but the due process claims are core to habeas and cannot be brought through standalone equitable challenges. Lots of case law they cite for us here. And their analysis is also not helped. Boasberg's getting hammered by the Supreme Court as well. Remember, they wrote in dicta that it is skeptical of the self-defeating notion that the right to the notice necessary to actually seek habeas relief must itself be vindicated through individual habeas petitions, somehow by plaintiffs who have not received the notice. And so the majority in another case was responding to another argument about class-wide relief, saying that how can these claims proceed for a putative class, or they could, not that they would apply outside of habeas. And so this actually supports us. That case was a habeas case. It was also filed in the correct venue. So nothing in that case calls into question anything in this case. Remember, the Supreme Court also punted in another case. And if anything, Boasberg's due process theory here is even more of a core habeas challenge because it involves removals. And they were unable to metamorphosize their habeas claims and into due process claims. You can't just transition it, right? Just change its pronouns from habeas to due process. I don't have habeas, but I have due process. What's the due process about? Habeas. Okay, nice try. Even setting jurisdiction aside, this court's injunction remains indefensible. Boasberg, indefensible, because the purely retrospective due process claim that the court identified is not redressable in equity, which is, theory of the law, essentially. When we talk about equitable relief, it's about balancing the sides, talking about injunctive relief, saying here, he explains it. There is no way for the district court to order an injunction. They are not in United States custody, so there's nothing we can do. You can't force us to do anything. So you can't order us to do this or prohibit us from doing that. We can't redress it here. The separation of powers prevents this court from ordering Trump to retake custody from El Salvador. You want us to order an invasion of a foreign country? You want us to be ordered to directly negotiate a diplomatic deal? It's not in your power there, Jeb. Again, Boasberg and their court correctly recognize that the United States doesn't have custody, and so the judge lacked jurisdiction. But still, Boasberg, reckless, ruled that their due process rights were violated when they were removed. They didn't get enough notice. And to remedy that injury, then he said you have to facilitate them getting new hearings. Even assuming that he has jurisdiction, that remedy is also internally contradictory. The government lacks custody. We cannot facilitate anything. You admitted it. Don't you read your own rulings? Insofar as the court intended for the government to facilitate the filing of habeas in the United States while they're in El Salvador, well, that problem's pretty obvious too there, Jeb. As the district court itself ruled, no federal court would have jurisdiction over these claims if we don't have custody. We're not going to release them. And so the ability to file a petition that no court would have jurisdiction over is not a remedy. It would not meaningfully provide them with anything. And so insofar as the district court intended for the government to regain custody, that's also an extraordinary and impermissible relief that you've already been rejected on twice. Separation of powers forecloses your attempt to do this. To regain custody of these gangbangers in CCOT, the government would have to take active steps to compel or persuade Bukele to release them. The district court's order thus yet again attempts to compel the United States to either use the military or force us to use certain diplomacies. Now, that extreme remedy unconstitutionally intrudes onto the executive's power over foreign affairs. Article 2 authorizes Trump to be the sole executor of the law, and Article 3 bars this court from meddling in these affairs. There is no standing here, and what they're claiming is speculative. Now here, as the district court found, El Salvador is not indifferent to any of this. In anticipating that the United States would be able to regain custody, mere guesswork is all they have. They're not providing any facts that they're going to transfer anything. They don't know anything about El Salvador because they don't run the branch. Thus, there is no evidence that El Salvador would release these people. And so this court doesn't have any power to create a remedy. So if you can't create a remedy, you can't hear the case. In the end, because it's not redressable by the courts, and we're not just here giving advisory opinions like I think you should do this or do this, like you got to do this or else. In the end, the only injury is a past one. They said we were removed without adequate notice, but that is not an ongoing or imminent injury. There is no prospective reason for injunctive relief. And so all of this means we should have a stay. The other equitable factors also favor a stay. To start, the district court's order, Boasberg, if not stayed, is going to irreparably injure the government. The order is intruding upon Trump's foreign affairs authority, forcing the United States to engage engage in military actions or either sensitive negotiations and to regain custody of over 100 gangbangers from a foreign prison. It is difficult to conceive of a more significant harm to the separation of powers. This illustrates why the harm to the government and the public interest merge when the government seeks a stay. You risk alienating a strategic ally. This has devastated countries before. If the United States were to seek the return of over 100 gangbangers that El Salvador has imprisoned for the purpose of giving them an opportunity to be released into our country, our reliability as a foreign terrorist fighting organization would diminish. And the sensitive and weighty interests of national security belong with the president and not with you. And so, DC Circuit Court of Appeals, you should grant a stay. These people are currently in El Salvador. We have no authority over them. And even if the district court's orders were not stayed, they would experience no change in their station. But if you don't grant a stay, Boasberg's dramatic and unprecedented order once again threatens to trigger a constitutional crisis, the sort of that this court diffused the last time we were here. The equities thus support Trump. Now, under the injunction, the government is required to submit a notice advising how they intend to facilitate them by tomorrow morning. The class of gangbangers, Boasberg said, give me an answer right tomorrow. Now, as set above, that requirement from Boasberg is premised on serious legal errors that would irreparably harm the government. And so you, Court of Appeals, should enter an immediate stay to prevent the harms from Boasberg, just like you did the last time that he demanded such a precipitous filing. And you should issue an immediate stay pending appeal. Signed by Drew Ensign over at the DOJ. Now, Court of Appeals in DC granted Trump victorious in the Court of Appeals. In a very short order, the stay attempt is successful. Upon consideration of the emergency motion for a stay pending appeal and an administrative order, it is ordered that those portions of Boasberg's crap order on June 4th, where he granted in part their motion for an injunction, granting in part their motion for class, and ordering a notice of Trump, all of that is hereby stayed. Boasberg blown out. Pending further order of the court. The purpose of this stay is to give the court sufficient opportunity to consider the emergency motion for a stay pending appeal and should not be construed in any way as a ruling on the merits. All right. Now, other responses are due by 5 p.m. Monday and then 5 p.m. next week on the 18th. And so, of course, we'll keep our eye on this one. But while all this is happening, we see that Boasberg and the gangbang lawyers are fighting for these people every single day in the media, on the cables, on X, just saying, these are really good and innocent people. Well, here's Trish from Ohio over in Homeland explaining their take on what's happening in LA.
Pretty extensive looting, Stuart. We've seen local jewelry stores being looted, Apples, Nikes. We've also seen more cars being set on fire, rubber bullets being shot at law enforcement. That's been an update as of last night, despite the fact that there was a curfew. Thank God President Trump had the foresight to call in additional law enforcement. This really was sprung by the fact that on Friday, we had surrounding ICE enforcement officers at a federal building. There were about 1,000 protesters, rioters really, who were far outnumbering our ICE enforcement officers. They were pummeling them with rocks. They were setting fires, burning American flags, defacing public property. And when President Trump saw that, and the LAPD took more than 2 hours to respond to bring in backup, we knew we needed more law enforcement, more military presence on the ground to make sure that LA is safe.
There was all the starving people just breaking into that, I think, Adidas store and Apple store to feed their families food, and so their babies can survive. Now, here was Hegseth. He was in Congress today getting questioned on the Senate Appropriations Committee by this woman called Tammy Baldwin. She's a Democrat from Wisconsin, and she was getting into it with Pete. Here's how some of that sounded like about what is happening with the Insurrection Act.
In terms of active duty Marines being deployed to California neighborhoods.
Senator,
so you'll follow up with me?
Yes, Senator, but there's plenty of precedent of active duty troops being used to support law enforcement. Historical precedent.
I'm not disputing that. I am just asking you to cite the authority under which the active duty Marines are being deployed to California.
It's in the order, ma'am, but we'll make sure we get it to you as well.
Thank you. I want to dovetail on a couple of other comments also with regard to the lack of specific detail in the budget request for the Department of Defense. I take great pride in Wisconsin's contributions to our national.
We're sure she does. The Insurrection Act is something that has historical precedent. We'll see if Hegseth and the DOD does it, but as it stands, Boasberg blown out today. He's got a stay. Doesn't mean it's a stay forever. The DC Circuit could always come back and and rule against Trump in the future. But the stay as it stands right now is a pretty good indicator that they're not liking what they're seeing from Boasberg, and he's already been backhanded a few times on this one. So another one coming soon. So we'll keep our eye on this one. Thanks for subscribing and joining as we do.